Good morning. It is another important case where Supreme Court has extensively interpreted Act, Labor Laws Act, Employees Compensation Act 1923, and as well as Employees State Insurance Act 1948. They used to wear parimateria. The concept was the deceased was a watchman of a factory. On fateful day, when he was reaching from his home to factory, because his duty was night duty, so there was a road accident and he succumbed to the injuries. So compensation was claimed, and the Commissioner of Labor come district judge directed to pay some 3 lakh plus interest, but that was set aside by the Honorable High Court. So the deceased family went to Supreme Court. Supreme Court has held a starring decision stating that Employment Compensation Act and Employees State Insurance Act as parimateria. Statutes of parimateria means having similar object, similar provisions. Therefore, they have held that the employee who is reaching his factory at any early hours to attend the function early hours, it is during his course of employment. That was the ratio held. His duty is from 3 a.m. to 11 a.m. 3 a.m. to 11 a.m. So they held. So many aspects has been discussed. This is the AAR 2025, Supreme Court 3532. So many words have been discussed. Particularly, Francis DeCosta case has been discussed, wherein they have held while reaching a factory outside the factory premises, it may not amount to accident during course of employment. That was clearly distinguished by the Supreme Court by this judgment. They have also out of employment, arising out of employment, paragraph 6, they have discussed about Webster Comprehensive Dictionary. Influenced, inspired and caused by. This was out of the essay. Then they have also discussed about these parimateria provisions and what is nexus. What is nexus also been discussed. Then they have also discussed about parimateria at paragraph 47. What is meant by parimateria? And they have read out the provisions of Compensation Act as well as State Insurance Act, and finally held that the employee who is commuting to his factory and whilst returning to his home will be considered as during course of his employment, and therefore the High Court judgment was set aside and upheld the award passed by the Commissioner of Labor come district judge, who was awarded 3,26,140 with 12% interest. And this is insurance company is bound to pay 50% on the employer and 50% on the insurance company. Ruling that did not occur in course of since that was set aside. That finding was set aside by the, and DeCosta judgment was also distinguished because of the present scenario, and they have rightly held these acts or beneficial acts for the purpose of protection to the employees. I hope this is AR 1997 SC 432 Francis DeCosta, where they have held that the outside of the court premises the compensation is not to be claimed. So kindly go through the entirety of the multi number of judgments were discussed. This is Devi Sala versus Oriental Insurance Company, AR 2025, Supreme Court 3532. Best wishes.